Being a landlord or a tenant in Colorado can be a complex task, especially when it comes to understanding the laws and rights that govern the relationship between the two parties. In this video, I will share important Colorado landlord-tenant laws. Colorado landlord-tenant laws vary slightly depending on the area, so every landlord must seek legal advice before drafting a rental agreement document for their property. A rental agreement, also known as lease agreement, is a formal contract that a landlord creates for leasing their property, residential or commercial. This document serves as a legal tool that indicates the responsibilities and rights of all parties involved in the lease. Usually, rental agreements are needed for tenants who are planning to rent for 12 months or longer. However, most landlords draft lease agreements regardless of the duration of the term. This provides legal protection against any issues. Colorado lease agreements include the following: contact information of all the parties involved in the lease, including the landlord, address and description of the leased property, lease duration, rent amount and due date, landlord and tenant responsibilities, miscellaneous clauses, including pet laws, smoking laws, and more. Colorado is considered a landlord-friendly state based on eviction restrictions and security deposits. Also, a little fun fact: Colorado is one of the few states that allows landlords to enter their property without notice. Here are some important things to know about Colorado landlord rights and responsibilities. According to the warranty of habitability, landlords must provide a habitable unit for every tenant, which includes running water, electrical wiring, heating systems, plumbing, fixtures, and more. On the other hand, landlords must provide repairs in a reasonable amount of time to comply with the warranty of habitability laws. Colorado tenants have the right to send a written notice of repair when they consider it appropriate, and landlords have up to 24 hours to fix the issue. Landlords also have the right to collect rent, deduct damages from security deposits when needed, and seek legal help if the tenant breached the terms of the lease. Tenants have the right to habitable housing whenever they consider it appropriate. This includes asking for utilities in good condition, getting repairs in a reasonable amount of time, and collecting their security deposit once they leave the premises. Additionally, tenants must comply with several requirements to keep a good relationship with their landlord. These requirements include paying rent on time, keeping the property free of trash or waste, keeping the property safe and in good condition, and providing any required repairs as long as they are minor. As stated by Colorado landlord-tenant laws, landlords are free to charge any amount of rent they consider appropriate for their unit, since the state does not ask for any specific requirements. Keep in mind that a Colorado tenant may withhold rent if they consider that the unit is not habitable. Tenants might withhold rent under these conditions if they provide notice of these damages beforehand. In most cases, the notice should be with a minimum of 10 days and a maximum of 1 month. There are no rent control regulations in Colorado, meaning that a landlord may be able to raise rent prices as much as they want without any problems. Additionally, they're not required to provide notice about rent increases. According to Colorado landlord-tenant law, there are no specific limitations or requirements to late fees. A landlord may charge late fees as an incentive for Colorado tenants to pay rent, and they can choose any value that they feel appropriate. However, it's important to note that the value of the late fee may be reasonable under specific circumstances. When it comes to paying rent in Colorado, some landlords may specify a grace period for unpaid rent. However, there is not a legal requirement in Colorado, so it's up to the landlord to decide if they want to include these clauses in their lease agreement. Want to download your own lease agreement template? Check out the link in the bio for your very own Colorado lease agreement template. While they're not a legal requirement in Colorado, most landlords tend to collect a security deposit in case of any damages that exceed normal wear and tear. Normally, the security deposit should be equal to the value of 1 month's rent. In case the tenant decides to terminate the lease and leave the property, the landlord must return the security deposit within 30 or 60 days. If there is a hazardous condition in the unit, landlords must return the security deposit in a maximum of 3 days. A landlord may withhold part of the security deposit if the damages exceed normal wear and tear, or if there are any pending utility bills or unpaid rent. A landlord may choose to evict a tenant for several reasons that imply a rental agreement breach. The most common grounds for eviction are lease contract breach, criminal activity, and withholding rent without cause. In those cases, landlords must give at least a 3-day eviction notice. notice. An at-will tenant may receive an eviction notice in advance depending on the time they've lived in the rental unit. The maximum is 1-day notice for weekly leases and 91-day notice for tenants who have lived in the unit for more than a year. A tenant in Colorado may terminate the lease early if one of the following required conditions are met: active military service, hazardous or inhabitable rental unit, domestic violence, early termination clauses, and other important lease clauses. According to state laws in Colorado, a tenant can be considered discriminated against for familial status, marital status, national origin, sexual origin, religion, and gender. Tenants can file a discrimination lawsuit online if they consider it appropriate. Just like I mentioned before, there is no specific law in Colorado regarding a landlord's right to enter their rental. Most landlords and tenants come to an agreement on a notification clause to avoid issues in the future. However, it doesn't hear eviction cases. Landlord-tenant agreements in Colorado usually have a maximum of 3 years for parties in a dispute to initiate legal proceedings. According to the landlord-tenant law, the landlord must give the tenant any information regarding lead paint if the unit was built before 1978. It's important for landlords and tenants to educate themselves on Colorado landlord-tenant laws and understand their rights and responsibilities. If you have any questions or concerns, it's always best to consult with a lawyer. Wow, that was a lot. I hope there were plenty of takeaways. Please like, comment, and subscribe. Thank you for watching, and I hope you have a great day. Also, don't forget to check out more videos.